Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. For the past 2 days, the arguments are going on in the BCCI case, Board of Cricket Control India. The main contention in this case is that there need not be any cooling off period for the candidates. Suppose if you are selected in the state, then as a member you can work for 3 years, then you will go to the BCCI, then you can work there for 6 years, then you should have the cooling period. That means for 3 years you should be vacant. You should not take any post in the BCCI. This is the previous rule, but in 2019 they have amended the rule and it was challenged ultimately. Now the discussion is, arguments are going on regarding this amendment. Actually, Mr. Saurav Ganguly and also Shah, both of them have already completed their 6 years of tenure and they wanted to continue in the BCCI for some more years. Therefore, in their view or for their support only, this argument have come into existence, whatever it is. So that case is there. That is BCCI versus Cricket Association of Bihar in civil appeal number 4235 by 2019. So from this it is going on. Anyway, very recently it has come up before the 2 judges bench of Honorable Justice D.Y. Chandrachud and Madam Hima Kohli. Right. So during the time of discussions, normally the judges will express the opinion, and you know that it is called as OBITER Dicta or passing a remark or opinion which need not have any bearing on the judgment. But yesterday, Honorable Justice D.Y. Chandrachud, he says that the social media platforms, they think that whatever judge says is a judgment. Even OBITER Dicta also, they are taking it as a judgment, which is not correct. But we can't help because social media platforms, we don't know from where they are being maintained and they do not have the basic knowledge of law also. This is the main problem. And you may be knowing, previously during the present, this present regime of in Andhra Pradesh, now and then the advisor to the state, he will be saying, the judges are saying like this, it is coming in the papers, let them put it in writing in the judgment. OBITER Dicta need not be put in the judgment. You know the famous case laws, B. Janakram versus State of Tamil Nadu 2017. There it is clearly stated that OBITER Dicta is an opinion, not necessary to become a judgment. Of course, it is only an observation to the law as to the law made by a judge. It is an opening part of discussion. Yes, if the judge asks, it is the duty of the advocate to clarify on the particular point. So therefore, on 13/9/2022, Supreme Court Judge G.Y. Chandrachud, he stated that oral remarks made during the course of hearing are merely for opening up of the channels for deliberations or discussions, and they ought not to be treated as judgments of the court. The social media often fail to appreciate the difference between the judgment and OBITER Dicta. Already I told you, OBITER Dicta is an open process of dialogue so that you can tell us whether we are right or we are wrong. This is the opinion of Honorable Justice D.Y. Chandrachud. But please remember, the problem is like this. Whenever the judge expresses opinion, so actually D.Y. Chandrachud sir, what he stated is that BCCI law is a private law. BCCI rules are private law. They can make any law. Why should the court interfere? Why should you interfere? That is the opinion expressed by Honorable Justice. So it is stated that justice is in favor of the so-called BCCI amendment, and ultimately the judgment has also, yesterday the judgment has also come in the same direction, that Saurav Ganguly and Shah can continue for more period and there is no cooling off period. As regards the cooling off period, please remember, rules are there. Suppose if a Supreme Court judge retires, he should not take up any assignment for the next 3 years because of the cooling period. But you may be knowing so many examples. Present NHRC chairman, immediately they join. So this is only for the sake of telling as a principle, but nobody is following. That's the main problem. But anyway, in this case, in this incident, what you have to learn is obiter dicta is different from judgment. Obiter dicta is only passing remark, an oral expression by the judge, because he is also a man. He is also a human being. So he can raise some topics, and they have to be clarified by the advocate. For that purpose only obiter dicta is used. But the papers, press persons, social media platform, they are thinking that whatever judges say is law. It is not correct. If you know this much of difference, it is sufficient, and please explain your clients also and other advocates also in this part regarding obiter dicta and also judgment. With this, I am stopping. Thank you very much.